We have a major update in the disturbing case of Laken Snelling, the former D1 college cheerleader who's accused of giving birth inside her apartment, allegedly letting the baby die, then disposing of the body and ordering McDonald's. She's now facing more serious charges in this case, and that could mean decades in prison. We're on the case presented by Law&Crime. I'm Chris Stewart. Hey guys, real quick, I want to tell you about this app, Upside. It can help you out in big ways because Upside gets you cash back, extra cash back on everyday purchases like gas, groceries, and takeout. So here's what you do. You download Upside, it's free. You claim an offer at one of their 100,000 plus locations, and you pay like you normally would with your card. Then you verify the purchase and you get money back. Say I need gas or takeout one night. I'll search Upside for offers first, then I spend and money appears in my app that I can just transfer straight to my bank. We're talking about real money here. Upside's frequent users earn an average of $254 back a year. And again, this app is free. So you can start getting your cash back. Click the link in the description, scan the QR code, and use promo code OTC to get an extra 25 cents bonus on every gallon on your first tank of gas. All right, a grand jury has just spoken, and it has made the case against Laken Snelling even more serious. This is the indictment that just came down. We also learned that an arrest warrant has been issued for Laken Snelling in the wake of the grand jury indicting her. This indictment reads, on the count of first-degree manslaughter, in part, quote, she caused the death of the infant or with the intent to cause the death of the infant under circumstances which do not constitute murder because she acted under the influence of extreme emotional disturbance or through circumstances not otherwise constituting the offense of murder. This is Laken Snelling. This is a video that she posted to TikTok. And this is a girl who went to the University of Kentucky. She was an athlete in the SEC, performing for a very special cheerleading team. And it just appears that she was living a normal college student life up until August of last year. But because of what she allegedly did on that day in her off-campus apartment, Snelling could now be looking at very serious prison time. A grand jury just indicted her on new charges, including manslaughter. Now, when you hear the details of this story that we're going to go through, you might wonder, why are we not talking about a murder case? And we'll talk about how the grand jury reportedly landed on these new charges in just a moment. So let's talk about this story because it begins on August 27th of 2025, the beginning of the school year, and it's around 10:30 in the morning that police in Lexington, Kentucky were called to Snelling's off-campus apartment. Now, this was a home that she shared with a couple of roommates. Again, very typical. Snelling was someone who had a lot going for her. Not only a student at the University of Kentucky, she was a varsity athlete. Now, when you think of varsity athletes at UK, and we were talking about the SEC, incredibly competitive, very talented people on these teams. And you have to be really talented to be a member of the Wildcats stunt cheerleading team. Now, this is not like the type of team you see on the sidelines at football games. This is a team that competes, it does a lot of acrobatics. You have to be very talented and very brave to be a member of a team like this. Snelling withdrew from school after her arrest, and she's no longer a member of that team. And we'll talk about what happened in that off-campus apartment. But on the cheerleading note, just to give you an idea of what we're talking about, this is a screen grab of the Wildcats competing. We found this on FlowCheer on YouTube, this video from April 2025. And according to court documents, law enforcement believe that the baby that we're talking about, the victim in this case, was born full term. So if this is from April 2025, Snelling taking part in the team, she was very much pregnant, considering she gave birth in late August. Now, as we dive into the details of this case, there is that question that still remains. And it's the question of why. And it's cliche to ask it like that, but you just have to ask yourself, why did this girl allegedly want to hide this pregnancy from the people around her? Why did she allegedly allow this child to die? And why did she allegedly not tell anyone about it and left it to her roommates to make this horrific discovery inside their off-campus home? So let's go back to that day, August 27th, when police were called to a house in Lexington for a report of an unresponsive infant. The child was pronounced dead on scene, according to police. This was a baby boy, and according to a subpoena, law enforcement believe that the baby was born full term. This child was found in a closet. There's an arrest citation that says the infant was wrapped in a towel inside of a black trash bag. The citation reportedly says that Laken Snelling was read her rights, and she allegedly admitted that she gave birth to that child. And then she allegedly said that she concealed the birth by cleaning evidence and putting all the cleaning items inside a black trash bag along with the body of the infant, who was wrapped in a towel. Now, the autopsy in this case could be incredibly damning to Laken Snelling's defense. According to People, the autopsy showed that the baby was allegedly born alive and died of asphyxia by undetermined means. There's also court documents that the student newspaper at UK, it's called the Kentucky Colonel, they were able to get those documents that reveal what Snelling told police after she gave birth around 4 o'clock in the morning on that day in August. She told officers that she didn't think the baby was breathing or alive, according to the student newspaper. And she also said that she was awake for about a half hour. She then fell asleep on top of the baby. And when she woke up, the baby had turned blue and purple. And Snelling reportedly said that she did not think the baby was alive. She then said she wrapped the baby like a burrito and laid next to it in what she called a moment of comfort. Now, this is all per the court documents that the student newspaper at UK were able to get. And it is interesting how that story compares with what Snelling reportedly told doctors later on. Now, when Snelling woke up for class that day, remember, she gives birth around 4 o'clock in the morning. Then hours later, she wakes up and she has class that day. And she says she allegedly wraps the baby in a towel, then puts the body in a trash bag, and then places the bag in the closet. Snelling also says that she reportedly cleaned up the blood in her room with paper towels and put the placenta in a Ziploc bag. Now, even though she just went through this major medical event and her son was dead, Snelling then reportedly left the house to carry about her day allegedly as if nothing had happened. She had class that day, and she said she was planning to go to class, but she didn't actually go to class. She said that she sat in her car, and the court documents say that she ordered McDonald's through the McDonald's app. Now, while all of this was happening, there appears to have been multiple roommates at Snelling's home. And around that time that Snelling reportedly said that she gave birth, one of her roommates had texted a Snapchat group that they thought that they heard something fall. And another roommate said that they thought that they heard noises for roughly an hour. After Snelling left for class, her roommates went into her room, and it appears she never told them that she was pregnant, but they were suspicious. And when they entered the room, they allegedly found a blood-soaked towel and a plastic bag containing evidence of childbirth, according to law enforcement. And they also say that they found the baby, and that is when they called police. Snelling eventually went to the hospital, and it is at the hospital where she told doctors allegedly that the baby displayed, quote, a little bit of fetal movement, and the baby made a, quote, whimper, and Snelling, quote, guessed the baby was alive. Now, these statements are going to be huge in this case going forward, and you can see how when we talk about manslaughter, how that may have played a role into the grand jury's decision. Now, Snelling's digital footprint may also be key evidence going forward in this case because it appears that police have images of Snelling during labor that she allegedly deleted. Police say in a request for a search warrant for Snelling's social media accounts, they say they could, quote, contain current or deleted information that relates to Miss Snelling's pregnancy, to the birth of the full-term baby, and ultimately its potential demise. Now, we have not seen those images. No one has seen those images. But again, another very key piece of evidence potentially in this case. Now, publicly, Snelling, she appeared to be active on social media up until the spring, when she stopped posting pictures of herself, from what we can see. Another shocking part of this is it appears that Snelling presented herself as someone who had aspirations to one day be a mom. This is the last post that she had on TikTok from June, and it's a picture with emojis that describe her. And in the bottom left, we noticed there's one that says goals, and it shows an emoji of a mom with a child. Now, another big question, who's the father of the boy that Snelling allegedly gave birth to? We know that an ex-boyfriend submitted DNA to police, and that Snelling was reportedly in a relationship with another man in more recent months, and that's just based on pictures that we saw before she gave birth, but it's unclear what their relationship status is right now. Now, before Snelling's case went before a grand jury, according to WKYT-TV, prosecutors issued a subpoena to UK Medical Center, and that subpoena demanded all of Snelling's medical records going back to August 2024, roughly a year before she gave birth, to now. So this arrest warrant, we've learned, has been issued for Laken Snelling in the wake of the grand jury indicting her and the fact that she is now facing this first-degree manslaughter charge, among other charges. Prior to today, Snelling's bond was set at $100,000, and she posted that. She's been on house arrest since her arrest last year. A judge at the end of 2025 did tweak her bond conditions. She has been wearing an electronic monitoring device while on house arrest, and she also, the judge ruled, can only be on house arrest at one location, opposed to splitting time between her mom and her dad's house. She reportedly has been staying at her dad's house in Tennessee, but with the news of this arrest warrant, that potentially could be changing. Now, the grand jury heard Snelling's case in January, and now a couple months later, we have learned that the grand jury indicted her on those serious charges, including first-degree manslaughter. And again, those other charges: abuse of a corpse, tampering with physical evidence, and concealing the birth of an infant. WKYT-TV spoke with the Commonwealth attorney about how the grand jury landed on manslaughter against Snelling, and that attorney said the grand jury was given information about the 4 levels of homicide in Kentucky, and grand jurors decided that first-degree manslaughter was the best charge for Snelling to be indicted on based on the evidence. I spoke with Eric Faddis, criminal defense attorney, before the news about Laken Snelling's arrest warrant broke. Joining us now to talk more about this case and where it could go next is criminal defense attorney Eric Faddis. Always great to have you here on Law and Crime. What do you make of the grand jury's decision? They could have charged her with murder, and they go with first-degree manslaughter.
Chris, I can't help but wonder if there was some sympathy in those deliberations that could have caused the grand jury to land on this first-degree manslaughter charge. Like you mentioned, that's a lesser charge than some of the other homicide and murder options they had with which they were presented. And so I'm just wondering if sort of that human aspect of all of this could have played a role in that charging decision.
Yeah, the Commonwealth attorney said that there were 4 levels of homicide that they could have gone with the grand jury, but they land on first-degree manslaughter. And from the narrative that has been reported, she gives birth, very traumatic experience to an extent, but then ends up hiding the body allegedly and then leaving for class. What would have been kind of that argument? What would have the argument been for this to be a murder case potentially?
I think if there was some malice involved, if there were some after deliberation, usually those are elements required for first-degree murder, and also the intentional killing. So if she had planned this out, if this is something that she had contemplated for quite some time, that this was how she was going to handle this baby coming, that certainly could have elevated the charge. But here it seems like, according to most public reports, that this was kind of something that happened very quickly, and she made the decision she made, and here we are. She's still charged with something very serious, but it's not the same as if she had sort of planned to kill this baby from weeks prior.
And she's facing, it's a lesser charge than what it could have been, but still, she could face 20 years in prison if she's found guilty on first-degree manslaughter. And she's also facing these additional charges that are still very serious: the abuse of the corpse, the hiding of pregnancy, or hiding the birth of a child charge. As a defense attorney, when someone is facing that top-line charge that could mean some serious prison time, how do you go about putting together a defense that also factors in some of those lesser charges that are also still very serious felony charges that she's facing?
Sure. I mean, it's a difficult approach, a difficult thing to navigate, no matter what. In looking at the charges, sometimes you look at those and you say, hey, the more serious charges are easily defensible, or more defensible than perhaps some of the less serious charges. And sometimes at trial, you even kind of make a bargain with the jury in a sense. You say, hey, look, she's admitting to one of these lesser charges, like hiding the birth of a child. That's something that she is telling you she's done. But that doesn't mean she's responsible for these more serious charges of criminally causing the death of that child. So sometimes you can actually try to use those less serious charges in a favorable way to get a better outcome at trial.
To my understanding, she didn't have a criminal record before this. She's out on bond. She may be a sympathetic figure to some jurors, But there's also, it seems like, scientific evidence that proves that it was her baby, that this baby was born alive, and then the baby passes away and she leaves. So there's kind of the rundown of the actions itself. Like, how does that typically play out in court? And I know it's jury by jury, where you have this sympathetic figure that some jurors may really feel sorry for, that all of this happened. But at the same time, if you're a prosecutor, you kind of give the bullets of what happened here, and that itself can be an incredibly strong argument to make.
Oh, most certainly. And I think, Chris, one thing you have to do is address that in jury selection. You have to really feel out what who these jurors are. What have they experienced? In this case, for example, if I was defense counsel, I might want some younger folks, especially younger parents on the jury who are just, acutely, intimately familiar with the challenges of having a child. But that can go both ways, because some folks might be on there, they might be young parents and say, hey, I went through all of this, and we, did what we were supposed to do as parents. We protected this child. And then this person chose a different route, allegedly. And so she could be looked at as less sympathetic in that sense. And I think if you get some older parents and even grandparents on the jury, they might look at this even less sympathetically as well. So it's really difficult. You sort of got to get into the personal experience of those jurors and how that might affect arguments from either, or how that might be how they might receive arguments from either side.
The Commonwealth attorney said that Laken Snelling, could be back in court in the next 2 to 3 weeks. Will she have to appear? And I know she's pleaded guilty to those other charges that she was already facing, but then does she have to enter an official plea, go through the whole process again when it comes to this new charge of manslaughter?
Most likely, yes. Yeah, there would have to be a plea to every charge that has been levied. And so, yeah, my apprehension is that she's going to plead not guilty. According to some reports, she has given statements that suggest that, from her perspective, this may have been an accident. And if it was an accident, then that changes the game completely, and really has bearing on whether they can find her guilty of these charges. Going to depend on sort of what the jury believes and how they see this sequence of events playing out.
How soon after an indictment comes down might the prosecution and the defense start talking about a deal and what that could look like, or going to trial?
It really varies by case. It varies sometimes by prosecutor, by defense attorney. But those negotiations could be taking place as early as now. They could have already have been started. I think both sides are probably motivated to reach a fair outcome in this case. Now, they might have very different opinions on what a fair outcome is, but I think there's still room to reach some kind of compromise given the somewhat unusual circumstances of the case.
And when it comes to her bond condition, she's out on $100,000 bond. I think she's spending time at her dad's house currently in Tennessee, and then she has to wear a GPS monitoring device. There are a lot of people that'll face these types of charges that will never get out ahead of a trial, but she's able to. Does a new charge impact potentially what her bond conditions could be if she's been following those conditions, which it does appear that she has since she was given them?
It very well could. In most jurisdictions, prosecutors are allowed to seek an increase of bond, just as defense oftentimes seeks a decrease of bond, a modification of bond conditions. Prosecutors can do that too, based on new information, based on new developments in the case, based on new evidence. And with this very serious charge of manslaughter, that could change the calculus in terms of bond, could convince a judge to cause her to be remanded back into custody while this case is proceeding. However, I think the judge might be more inclined to maintain the status quo to the extent that the defendant has been complying, which it sounds like she has. So she may still receive the benefit of being able to fight this on the outside.
How problematic is it that she left the house after all of this happened? Because there's been different reports about what her side of the story is, and there is this medical episode she had, which in some ways is very traumatic. But then there's that decision of I'm walking out of here. And she wasn't the one who called 911. It wasn't even that she had some come to Jesus moment, apparently later in the day, where it's like, I need to call police about this happening. It was her roommates that had to make this discovery. Like, if you're the defense attorney, like, how do you handle that fact?
According to some of the reports that I've read, Chris, I think the defendant is going to lodge the defense that this was an accident, that this child was born, and during that birth, the defendant passed out and rolled over on the child, causing the child to not be able to breathe and die. And so from there, at least according to the defense, the defendant then put the child in a towel and into a closet, I believe, and then just left. Now, certainly, that's a problematic fact for the defense. It might appear callous. It might appear heartless. So I think defense really has to sort of humanize that piece of this by saying, hey, this was a young girl. She was freaked out. She didn't know what in the world to do. And she made the wrong choice. But that's not the same thing necessarily as making the criminal choice. And if the baby was deceased by the time that the defendant had left the baby in the closet, that gives rise to less criminal culpability than if the baby was still alive and just had to suffer there and die.
And we still have a long way to go to see of whether or not this actually goes to trial. But if she wasn't to take the stand in her own defense, like, how do you build that sympathetic figure if you as a defense attorney are not going to have her in kind of the line of fire of prosecutors who could come back?
Sure. So you have to tell the story through the voices of others if you can't tell it through your own client for legal reasons. You would call potentially family members, friends, classmates, things like that, to just talk about the defendant's state, perhaps her immaturity at the time, perhaps her, how she was dealing with this transition, going to college as a young person, and then, oh my gosh, she's also pregnant on top of that. So I think you sort of tell it from the observations of the people around her, who would try, from the defense perspective, to humanize and sympathize this defendant.
And then when it comes to potential penalties, I mean, if she's found guilty, I mean, how likely is it? I mean, she's never been in trouble with the law before. She may be this sympathetic figure because of that. How likely is it that she could end up in prison based on the charges that she's facing?
I think that anytime you're looking at a manslaughter charge in and of itself, prison is on the table. And when we're talking about a newborn, that ups the ante. That really is an aggravating factor. So I think if she was convicted of the most serious charge of manslaughter, I think the court's going to look at that extremely seriously. And I think there's a reasonable likelihood that she would go to prison if she were convicted.
And then when it comes to negotiations, like, how does that actually work? I mean, if she's someone who does not want to go to prison, and I know you probably have to have some really serious conversations with clients about the reality of, like, this could end up that way. Where does the negotiation begin? Is it you as the defense attorney typically that's picking up the phone after an indictment being like, all right, what are you guys looking to offer?
It depends, Chris. Oftentimes on the defense side, and I've been on both sides, usually on the defense side, it's advantageous to have the prosecutor make the first move, to have the prosecutor make the first plea offer, because then you can negotiate from there. That's sort of, now that's worst case scenario as a plea offer. And you try to chip away and exert leverage and try to get a better outcome from there. But those discussions are usually pretty candid. And in fact, they're typically not admissible in court. So if those discussions break down, if defense went to the prosecutor and said, hey, for these reasons, X, Y, and Z, she was a young kid and she freaked out, she made a horrible call, let's give her some kind of break, and that doesn't work. Usually those discussions don't come into trial. The jury never hears about it. So it's something that happens behind closed doors. And can be those discussions not only difficult with the client, but can be difficult with the prosecutor in an emotionally charged case like this.
Yeah, definitely an emotionally charged case. Big step forward now that she has been indicted. We'll see what happens next. Eric Faddis, criminal defense attorney. It's always great to have you on Law and Crime. Thanks for being with us.
Great to be with you, Chris.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify, and we're also streaming on Peacock. I'm Chris Stewart. We'll see you next time.